Hello everyone, I welcome you at Swayam platform. We are discussing a course Hindu personal law including marriage and succession. Before starting anything, I want to discuss about the previous lecture where we discuss about the source of Hindu law and we primarily discuss with the Shruti and Smriti. We understand that the Shruti contains limited number of legal text but Smritis is a vast and includes variety of law. We focus on the Vyavhar where we discuss about the 18 title of Vyavhar which prominently mentioned in Yagyavalkya Smriti, Manu Smriti, Narad by the Kautilya in Arthashastra. We understand that every Smriti contains three different portions, Achar, Vyavhar and Prayaschit. Conflicts within the Smritis is possible. Why? Because Smriti is written in the different part of India and different time span. Therefore, problem and conflicts may exist. The fundamental question is how we can resolve the conflict. In a case of conflict, the logical portion of Smriti will prevail over the illogical portion. And in a case of conflict, Smriti Virodhe Vyavhar Balavastu. We focus on the custom and we also focused on the behavior of good learner. Friends, now in order to expand the idea of the source of Hindu law, today I want to focus on the third source which is very relevant is commentary and digest. Today's lecture will be focused on commentary and digest as a source of Hindu law. Friends, first I want to discuss the learning objectives of the today's lecture. The first one is we will learn the significance of the commentary and digest as a key source of Hindu law. Why it is key source? Second, the role of commentary and digest in the development of Hindu law. And the third is major commentaries and digest and their scholars. And we also focus on the adaptable nature of Hindu law. So these are the fundamental learning objectives, and in the light of the learning objectives, I am going to start my discussion on commentary and digest as a source of law. Friends, the first fundamental point is how we can define the idea of commentary and digest, because generally people think that commentary and digest both are same, are like similar, but these commentary and digest have a fundamental difference. For example, commentary means an expression of opinion, a series of comment on a specific text is commentary. Means when a scholar writes something in order to explain any particular smriti, then the commentary came into the existence to explore critically, evaluately about a smriti. Therefore, commentaries are the detailed explanatory notes written by the scholar on the original smritis. For example, Medhatithi commentary on Manu Smriti, where Medhatithi explain each and every context of Manu in the specific context. Now the second one is the digest. Digest means compilation of the information on concerned subject matter from several sources. It is the compilation or collection of all relevant material including law and custom from several sources on any topic of law. For example, Kamlakar's Nirnay Sindhu. Friends, we must be carefully understand what is the concept of commentary and digest. Commentaries means commentary on a text. For example, Medhatithi's commentary on Manu Smriti, where Medhatithi explain each and every text and sutras written by Manu. And second one is digest. Digest means we compiled law from several sources on any particular point of law. For example, Dattak Mimamsa, Dattak Chandrika. Digest writers compiled law on adoption from different sources. So this is the fundamental concept of commentary and digest. Therefore, we should be very clear that both are distinct and different in the context as well as by its nature. Now, I want to focus on the main features of the commentary and digest, because why commentary and digest are relevant must be explained properly, friends. The first point is, the authors of the commentary and digest have tried to make subject simple and easy to understand. Smriti writers laid down various provisions in the sutra form. Therefore, they use the terminology in highly technical and concise manner. But commentator and digest writers make entire subject matter simple and clear, because they came with the different meaning, illustration and examples. Therefore, commentary and digest are simple exposition of law. The second important point is, their authors have given a definite meaning to the doubtful and difficult portion of Dharma Shastra and try to resolve their mutual conflict. The second point explains two fundamental points. The point is, every technical term is explained in detail by the commentary writers. For example, Mitakshara. When you are going to study the Yagyavalkya Smriti, the number of rule is written in the sutra form, but Mitakshara explain each and every sutra with illustrations. So we have a number of examples where we can discuss about the what is the difference between the Mitakshara as a commentary and what is the provisions of Yagyavalkya Smriti. Now I want to focus on the third point. Commentaries includes the quotation of several works in order to explain the particular text. This is very unique point. They want to explain, they want to support what is given in the Smritis and what is their understanding on the basis of the matters available in different Smritis or in different sources. The best example is Aparark commentaries on Yagyavalkya Smriti. Aparark's commentaries includes many things, many materials on existing points. It is very detailed and simple. You can realize the law truly with the help of Aparark commentaries on Yagyavalkya Smriti. The next point is, friends, the commentators and digest writers have widely classified the topic of law because they are more contemporary. Therefore, they, on the basis of the changing need of the society, they broadly classified each and every provisions of the law and presented in the simple form for the public as well as for the administration of justice. The next point is, friends, the commentary and digest have included the custom and uses prevailing at the time in which they were written, the commentary and digest. This point is also crucial because with the help of commentary and digest we are able to understand the custom of prevailing time, variations of customs and what kind of customs were recognized relevant by them. So these are the important main features of the commentary and digest which aids substantial value. Therefore, the commentary and digest is recognized very significant when we discussing about the source of Hindu law or where we are going to apply the source of Hindu law. Therefore, Indian courts primarily and fundamentally quoted Mitakshara, Dayabhag when they decide the cases. Not only Indian courts, Privy Council also broadly quoted the Mitakshara and Dayabhag while they involve in the resolution of a dispute. And this is the features of commentary and digest. Fundamental question is, why commentary and digest have been written? Justification of writing of the commentary and digest. The first point is, Smritis presented an unsystematic form of law, because Smriti includes many things written at the first stage of civilization. Therefore, Smriti contains the unsystematic provisions of law. Therefore, second point is, some of the rule of Smritis expressed law as a general principle without necessary qualification and explanation. Smriti writers produce the law because they understand that people have broad understanding, they understand the sign and symbol. But due to the passes of time, people not become so capable to understand the exact meaning what they want to refer that. Therefore, commentary writers simplify the entire text, and they also added the different kind of qualifications and exception of the rule which is given in the Smritis. And why they added qualification and exceptions? Because they understand the need of contemporary society. They also understand the day-to-day activity of the courts, and they also understand the problems faced by Prad Vivak. So therefore, considering each and every aspects and what they experienced, therefore they simplify the provisions, they add exceptions in the provisions, they also add necessary qualification for the purpose of application of Hindu law. This is the point. Therefore, commentary and digest is required in Indian society. Friends, we may also explain that a comprehensive view of the content of the Smritis is required to be synthesized to create to the need of a society. Means, friends, we should focus on the specific point. As per the need of society, everything should be modified and should be classified, and therefore in consonance with the need of society, Smritikars presented something and digest writers, Smriti writers put emphasis and simplify the same things. And I am also bound to say that in some context, Smritis are incomplete. So therefore, in order to simplify and fulfill the incompleteness of the Smriti, commentator play very pivotal role, and therefore we need a synthesis, and therefore we have a commentary and digest. Now I want to focus on the role of commentary and digest in the development of Hindu law, because during the medieval period, which started from 800 AD to 1700 AD, entire development of Hindu law is totally dependent as well as based on the commentary and digest. Therefore, we cannot ignore the role of commentary and digest. In one hand, commentary and digest writers simplify the Smritis. In another hand, they add interpretations, they add qualifications, they add exceptions, and they simplify the overall language. Therefore, they play a very crucial role in the development of the law in India. Friends, the fundamental question raised by the critique that entire Hindu law developed only due to the armchair methods. Sages in forest, in the state of meditation, derive certain principles, and the principle have no connection with society. These is a narrative which have no substantial value. Therefore, we should focus on the fundamental point. Our commentators and Smriti writers as well as the digest writers learned something from the day-to-day practice of the ancient court and the Prad Vivak, and on that basis they developed the law. Therefore, they play a very crucial role in the development of the law in India. We may synthesize the entire context in the following points which I am going to present before you. The first is, friends, commentators did not hesitate to interpret and explain the ancient text so as to suit the need of the progressive society. They not in hesitation, they understand the need of society and they apply their intellect in order to simplify and in order to explain as per the need of the society. Second, the authors of the commentaries and digests actively participate in the process of the development without claiming any delegated authority. Nowadays we are talking about the delegation and delegated authority, where parliament delegate the powers to executive and executive let down the rules. But such kind of delegation was not that time. But scholars think that this is the need of society, and as the part of society they think that they should contribute in order to simplify the law. Therefore, they simplified the law and presented before the society for the purpose and the benefit of society, friends. So, this is the difference between the modern and the present practice. Means without any delegation power, they did something for the benefit of the society and for the benefit of the administration of justice prevailing that time. Authors and commentaries and digests try to explain, modified and enlarge the tradition recorded in Smritis and try to bring harmony among Smritis. They try to bring harmony among Smritis. For example, Manu quotes that marriage should be before the age of 8 years, a female may be married. But when Medhatiti tried to explain the same provisions, Medhatiti written that 8 year is minimum age. So, this is the development of law. Manu that time noted and explained that the age limit for the marriage for a girl is 8 year. She should marry before 8 year. But Medhatiti further explained that 8 year is minimum period. Therefore, girl may be married after the 8 year. So, this is the different how the commentator put their intellect and explain the law as per the need of the society. This is one of the examples which we can trace in the commentary. Now, friends, the period of commentators and digest is between the 700 AD to 1700 AD. The commentator and digests are not developed by the scholar by adopting the armchair methods. These are based on the practical working of the administration of justice prevailing in that time. This is very crucial point. The last commentary was known as Baijanti, written by the Nanda Pandit. This is the very important point, friends. Now I want to focus on the commentary again. The commentaries, while professing to interpret the law as laid down in the Smriti, introduce changes in order to bring into the harmony with uses followed by the people governed by the law, and it is the opinion of the commentator which prevails in the provinces where their authority is recognized. How we can explain this thesis? Suppose if you as an authority residing in a particular country, if you have a delegated power, then your opinion about the law will prevail in particular locality. But scholars' opinion recognized in particular locality because of their scholarship and experience and sadachar. This is the fundamental principles of working of our traditional system and modern system. Today's your order is followed by people because you are the representative of sovereign which have a command in the hand. But in the past, your order is followed by the people because of your sadachar and scholarship. So, this is the difference and which is a unique point which should be considered when you are thinking about the role of commentary and digest. In a case of conflict between the ancient text writers and the commentators, the opinion of later was accepted. In a case of Atmaram versus Brijrao, now I want to focus on the principal commentaries, includes Vigyaneswar's Mitakshara, दायभाग of the जिमुतवाहन, मित्र मिश्र का वीर मित्रोदय, वाचस्पति विवाद चिंतामणि, and Chandeswar's Vivad Ratnakar. These are the principal commentaries. I will discuss about the principal commentaries and I discuss the school of Hindula in detail. Somehow I try to accommodate in my discussion. Friends, now I want to focus on the commentaries on Manu Smriti. मेधातिथि मनुभाष्य गोविंदराज मनु टीका कुल्लुक भट्ट मनु अर्थ मुक्तावली. Bharati Vidya Bhavan compiled 9 different kind of the commentaries on Manu Smriti. You may search it from the Bharati Vidya Bhavan websites. Friends, now I want to focus on the digest. Digest are the collection of the law and the practices on a particular topic of law. Scholars started writing and the digest around the 12th century. I already told you that digest means compilation of material on a particular topic of law. Means you are explaining a topic of law with the help of different provisions, different text available in a society or in a legal system. So now I want to focus on the prominent digest. Smriti Chandrika Devan Bhatt, Chintamani written by Vachaspati Mishra, Dharmaratna written by Jimutwahan, Dattak Mimamsa Nanda Pandit, Dattak Chandrika by Kuber, Bhagavant Bhaskar Neelkant, and Vyavhar Mayuk by the Neelkant Bhatt. Vyavhar Mayuk subsequently translated by the great scholar of India P.V. Kane. It is very useful to understand the entire context of the digest, friends. Friends, if you try to focus on Mitakshara written by Vigyaneswar, it is the most important commentary on Yagyavalkya Smriti and was written in the later part of the 12th century. It is accepted all over the India except Bengal and the northeast region of the India. Even in Bengal, it is regarded as authority of the all questions where there is no express conflict between it and Daibhag. It includes all the aspects of Hindu law, including the law of succession, kopasnary, partition, debt, and Stridhan. It also emphasizes the various Smritis text. Mitakshara is very wonderful, very informative, very analytical. It explains each and every portion of the Yagyavalkya Smriti. You can't understand the provisions of Yagyavalkya Smriti without quoting the Mitakshara. Mitakshara is so detailed, so extensive, and therefore Mitakshara acquires significant place, and therefore British courts and still now Indian courts focusing on the Mitakshara. Mitakshara also influenced a lot in the development of the modern Hindu law. For example, father is now recognized as a second class heirs. Mitakshara also contains that so long as mother exists, father have no rights in this heir. Means Mitakshara play very pivotal role, very extensive, therefore Mitakshara is very crucial. Now friends, I want to focus on the Jimutwahan Daibhag. It is prevalent contemporary in the Bengal and it followed by the part of the northeastern region in India. It mainly deals with the law of succession and partition. The main difference between these two principal commentaries, Mitakshara and Daibhag, are related with the law of inheritance and partition. So I will discuss the Mitakshara school and Daibhag school, where I discuss the detail about the Mitakshara and Daibhag, the principles contained in Mitakshara and Daibhag. But just because these two are the prominent commentaries and therefore we can't overlook the contribution of Mitakshara and Daibhag, because these two texts quoted in India by the Privy Council, Federal Court, Supreme Court and different high courts, and the modern law of contemporary India, somehow we may relate with these two prominent commentaries which is prevailed in India. Now we can think about the conclusion, friends. The commentators amplified narrow provisions of law, thereby materially contributing to the process of the development of law. This is very important point, because after the Smritis, still we have a continuity because of the commentators. Nowadays, commentaries on Hindu law is not going on. Therefore, these commentaries play very crucial role to connect us with our tradition, with our roots, because they work as a bridge. Second is the acknowledgement of their scholarship was indeed so remarkable that their opinions and conclusions become law by acceptance. This is the idea of institutionalization and internalization of the law. They let down something which is institutionalized by the state, and simultaneously it is internalized by the people. Why it is internalized the people? Because people accept that. This is the beauty of Hindu law, where people accept the law, and because of the people acceptance, a text become the law text, so prevalent text. And this is so neutral observations of these two, commentary and digest. The third point is the law was essentially traditional and rooted in the custom, what explained by the authors of the commentary and digest. The process of the development and assimilation continued. The law reflected not only the ancient text but also rule of the conduct and practices. Therefore, these commentary and digest are very significant status in our system. The different commentaries came to be referred as to the chief guide of the law in different part of the country, where the authors were accepted as preeminent authorities. The result of the two principal school of Hindu law, Mitakshara and Dayabhag, sprang into the existence. Furthermore, in regions where the Mitakshara prevailed, a number of sub-schools emerged. The result was that two principal schools of Hindu law, Mitakshara and Dayabhag, came into the existence. Furthermore, the regions where the Mitakshara prevailed, a number of sub-schools also emerged. On the basis of these context, we may think about certain points. Why did commentaries emerge when Smritis already exist? Please think about that. Have the authors of the commentaries and digest succeeded to addressing the changing need of society? Please focus on that. How did the Mitakshara school and Dayabhag school of Hindu law emerged? We can think about that. Before closing today's discussion, I want to conclude my entire discussion about the commentary and digest. Commentary and digest is so crucial for the purpose of simplifying the law. They used the authority. They are not delegated by the rulers, but their scholarship was so prominent. Therefore, by acceptance, their interpretations become authoritative. An entire development of the Hindu law as well as the continuity of these traditions continues because of the commentary and digest. But be careful about the meaning of commentary and digest. Commentary means commentary on a particular text, means book. For example, Manu Smriti, Yagyavalkya Smriti. But digest means conclusion on a specific topic of law, compilation of the legal material on a specific topic of law. So we should be careful about the meaning, and we should think about the development and why they emerge in a society, in a legal system. And the very important point is we must focus on how the continuity is still prevailing in India due to the commentary and digest. And by closing this remark, I am thankful to you all. Thank you.